Very good evening to one and all. Welcome to the October 2021 monthly Labourlaw update. Keeping with the festive season where everybody will want to be going out, I think for whatever reason, this month's update is going to be really brief, I feel. There's nothing much that either we have about legislative changes or executive changes that has happened this month. So there's just going to be a few case laws that maybe we may be touching upon, and we'll be really brief this month. The Tamil Nadu government, we have already, during our earlier presentations, informed you of that they have amended the Labour Welfare Fund and increased it. And now that this amendment has also got the assent and therefore it has become a law, the annual contribution to the fund has been increased as shown from 10 to 50 and 50 to 100 from the employee and employer side. So this has come into force and this would need to be complied going forward. Similarly, the Himachal Pradesh government has made certain changes to its rules providing for certain additional benefits in respect of construction employees. So the building and other construction workers rules has been amended to provide for certain benefits in Himachal Pradesh. The ESI Corporation has extended the benefits of ESI in Tripura as well as in Assam to various other districts of state of Assam as well as state of Tripura. Employees who have factories in these locations would now need to cover their employees under the ESI Act. We have a very simple question this time. A pregnant woman will be entitled to maternity leave of how many weeks? We'll see the answer at the end of the session. This was again a reiteration of earlier news that has come about that whether GST should be collected from employees and whether it will be part of GST. It has been clarified again that the payments collected from employees towards canteen will not attract GST. We also saw about the Uber judgment of the Supreme Court in earlier months presentation. The question was where the Supreme Court of United Kingdom has held them to be drivers. Now Uber has, of course, they don't have any other choice. They have began to implement the order and ensured that not only wages, but holiday pay, pension, and other benefits are also being extended. So we need to see what this context will have, especially when our labor codes come into force, where our social security code contemplates of covering gig workers. So what will be the effect of it, we need to be seeing soon. This month's Knowledge Corner, we thought we will touch upon the EC Act. It was earlier called the Workmen's Compensation Act of 1923 and subsequent to its amendment, it is now called the Employees Compensation Act 1923. It has the occupational diseases, and when an injury arises in course of employment, both these, the employer becomes liable. Of course, if an employee is covered under the EC Act, then the EC Act doesn't come into picture. Is one of the major things that protects you. ESI benefit helps employers to get over the EC Act compensation. A very particular issue on EC Act is the doctrine of notional extension. So the Act itself provides for compensation only in the respect of injury in course of employment, but courts have extended this theory. To what extent is something that we are just trying to analyze. A very few cases we thought where there are exceptional cases that came about. So this is a case of where employee was going back to, I mean, it is now initially the notional extension theory was while coming to work and going back is also covered. Then subsequently even the Act has been amended to bring in that your to and fro to work will also be covered as being in course of employment. But in this case, the employee was at a route which is not a routine route to be taken to work, and therefore in this case it was by the Orissa High Court held that he will not be entitled to the benefits. This case of the Himachal Pradesh High Court, wherein the benefit of the Compensation Act was not extended, but this is a case where these are cases where stress levels, stress leading to death has also been considered to be in course of employment, and that has resulted. So there are a line of judgments where a heart attack suffered by an employee has been considered as an in-course employment. It's though there is no injury, they have considered that to be an accident arising, and they have given. This court arising from this judgment arising from the High Court of Tripura is again where it is beyond the scope of the employer. Of course, the employee was on duty, but he got assaulted by the public. Somebody from the public assaulted, and it's got nothing to do with employment or stress or anything. But then the assault was also considered to be an accident that occurred as part of his employment by the Tripura High Court, and the Tripura High Court granted relief to the employee concerned. This was again nothing to do at all, strictly speaking, with the employment, but the question that the High Court took up was, if not for his employment, he would not have been in that place where this accident occurred. And it is based on that it was held that he would be entitled to the benefit, though it is really not a work-related injury. As I said, these are all again heart attack cases where even the Supreme Court has held that the Karnataka High Court, there have been also subsequent Supreme Court judgments where they have held that the benefit of the Act will be available even to an employee who suffered heart attack owing to his work nature. This was the term arising out of employment, where the person injury was there. They said it is to cover cases where even there is no direct connection to the employment, it will still be covered. This is a case where a bomb blast was there near the place of employment where he suffered an injury because of it. And they said that, again, going by the theory that he would not have been in this place except due to work. So it's only due to the work, and he was doing work, that he was there in that place. Though the injury itself was not caused due to the work, but it is again a notional extension of the theory that the injury was suffered arising out of his employment, and courts granted compensation. So the principle behind Employment Compensation Act is something that we thought we will highlight in this month's Knowledge Corner. The purpose of the Act, the judiciary is at all times trying to extend it further and grant more relief to the employees. But at the same time, when it is outside, completely outside, when you're not on your way or you take a detour, even when you're coming to your work, you take a detour, or going back, you take a detour, then you don't. But otherwise, it is the injury could be not related, but if it is due to the employment that the injury was suffered, then courts have come to say that a compensation would be payable. Under the Gratuity Act, already there is a provision for imprisonment in event of non-payment of gratuity, but under the Code on Social Security has been made as 1 year imprisonment or fine up to 50,000. Similarly, non-payment under the Code on Social Security of Provident Fund or ESI, it's up to 3 years. Imprisonment of 3 years and fined up to 1 lakh, both could be levied. The vaccination drive from the corona pandemic, we just thought it's an interesting that an airline in the US I said it's going to terminate employees who are not getting vaccinated. Can you do this, India? I think at the moment it's a big no. You can't be terminating employees, but of course there are other methods by which employees are trying. It's a very current topic that is there, but we don't have any judicial pronouncements which support an employer or empowers an employer to terminate an employee who fails to get vaccinated, nor are there any guidelines by the government in this regard that will enable an employer to terminate. We are just pointing this out so that the government, in the best interest of the larger interest of those working, could come with some guidelines or regulations which could be enforced by employers to ensure people get vaccinated or deny them employment based on that. This is a club where they also have a eating house. So the question that came about was whether it will be part of a shops and establishment. Because it is an employee was terminated and he raised a dispute saying that he was working in a restaurant. But the primary activities was of a club, and it was, first of all, it was not open to public. Secondly, it is not an eating house per se, in the sense it is not just the restaurant alone, but there are other activities also. Therefore, the Supreme Court upheld, saying that the restaurant or the food facility was one among the various facilities that are being provided by the club, and therefore the provisions of the Shops Act will not be applicable. However, please do note that the definition of establishment varies from state to state. This judgment pertained to Madhya Pradesh shops and establishment, and going by that definition, this judgment was rendered. So in each state, it could vary. So that's one of the reasons why we put this judgment, to show that how the definition of the establishment in each act could take a different connotation. There is a lot of judgments on this, more to do with public sector undertakings and public employment, where the government establishments, corporations, which are not under the government but established by the government, various boards like electricity boards, your water boards, etc., where people get into employment and then they, not through the regular channels of employment, but through backdoor. And time and again, Supreme Court has been reiterating that these kind of persons can't be brought in which will not be in consonance with the constitutional framework. And once again, in this case, the Supreme Court has reiterated that you cannot bring in people or regularize them when there is no post or they have not been done through a proper channel of recruitment. When there's a policy matter of the government, the high courts or the court should not be interfering with regularization of casual workers. We have a complaints calendar, primarily PF and ESI and professional tax in certain states that would need to be paid in the coming month. A worker welfare fund in Kerala that would also have a remittance to be done. Coming back to a quiz question, it's 12 weeks. So your maternity benefits, the correct answer for the quiz is 12 weeks. As I already said, it's not our fault, I would say, but there's been very little development in the legislative side as well as in the executive, and therefore this is the updates we have. We hope to connect with you again on 4 p.m. on 27th of November 2021. Please do join with us. Thank you.